I mean, if it's business, it's business. If it's family, it's family. You may take the position at any time that, my cousin's going to live here, and if they can't make rent, it's not going to break me. I'm kind of doing this as a charity anyway. But you go in with that understanding, as opposed to, if I don't get rent, I can't make my note.
Right.
And if that goes on for too many months, I'm sunk. I might lose the house in foreclosure. That's a bad situation. Don't ever set yourself up in that way. If you can swing it without ever getting rent from them, maybe it's not encumbered in any way, you're just paying the taxes and maintenance, then yeah, maybe you can rent it to your cousin, and if you get rent, great, and if you don't, it's not gonna kill you.
Ernie, you had some additional stuff for 1 and 2, and why don't you just start off on that?
Well, other portions of that tenant scorecard that I talked about in the main broadcast have to do with things that landlords don't usually consider, or at least they don't pay enough attention to. One of those has to do with pets. And you can score your potential tenant based on the kind of pet that they have or the number of pets they have. For example, you may find that a perfect tenant has 0 pets. But here's what we know. 80% roundabout, about 80% of people who take rental property have pets. Whether you know it or not, it's very likely that your tenant is going to have a pet. And so you probably want to address that up front in your lease. And many landlords have provisions in their leases that say, if you have an unauthorized pet, you owe me $500 in a pet deposit, and yada, 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 yada.
Let me jump in and ask you, what happens then when you have this no pet policy, you find out they have a pet and you allow that? Does that compromise your lease, compromise you in other positions?
Well, number one, you've compromised the property itself, because you have not accounted for the damage that will inevitably occur from the presence of that pet. Nominal damage to major damage, hard to predict. But, if the tenant has a parakeet, that's going to be different than if they have a Great Dane, right? Or multiple of them. And so you can judge going into a lease the potential for, carpet cleaning or, scratched flooring or other matters that are going to be affected by the presence of that pet, and that can go into your calculus, right? You can decide, I'm fine with 1 pet under a certain weight limit. I'm fine with multiple pets so long as they don't do X, Y, or Z. But the idea of pets has to be in your rental scorecard. You have to take this into consideration, and you have to insist that the pets that will enter the premises are all documented. You got to make sure that they are breeds that your own homeowner's insurance policy will allow, because there are certain breeds that might actually jeopardize your policy. Most landlords don't know that.
Like a pit bull or?
Correct. Or a pit bull that has a history of, biting. They may have gotten that one bite. Well, they don't usually get into trouble. He's a good dog. She's a great dog. But if there's a history with 1 bite, your bite could be the second one that gets you in a lot of trouble. Right, so if this pet has some kind of history, you need to know about it. That's a red flag. And so the other is they disclose the 1 pet, but then you show up to inspect, and it's something that I recommend landlords do at least once during a year term, if not twice. Have a scheduled inspection of the property
and document that.
Well, yeah, not just document it. I mean, let the tenant know, hey, it's January. I'm going to be here in April, and I'm going to be back in August. I do this twice a year. I do it with all my tenants, and I'll let you know ahead of time that I'm coming. And they may tell you, oh, don't worry about it. There's no need. Everything's running fine. Great. I just want to go and check it out. I love seeing my property. You might check things like, the AC vents. You want to make sure the air conditioning's working. You want to check the walls and the roof. But you also want to inspect the condition of the property that we don't usually check, like the presence of unauthorized occupants, or the presence, in this case, of an unauthorized pet. Right, because you may have Sparky listed in the pet addendum, but you didn't get Sparky's brother, and now the 2 dogs are going to cause mathematically twice as much damage. But if a separate deposit has not been paid for the presence of a second pet, your property is at risk of additional losses, and you don't have any security for it. Landlords, as always, we welcome you to follow us on our Instagram page. If you're not a member yet, join us on Facebook. And if you enjoy what you see here, give us a thumbs up. Click that like button. We enjoy that very much. And if you haven't subscribed yet, please consider subscribing.
Now speak to the person that, you want to be a giving person and then you want to give some slack. They got the second pet. You really need to document that, but you don't want to be the bad cop. And so in this case, though, it's the lease that's the bad cop. You get to be the good cop because, because we go by this. This is for my protection and your protection too. We just have to document everything. I'm trying. What words of encouragement can you give based on your experience in working with these reluctant lease enforcer landlords? Nice people that are otherwise just getting screwed because they're nice people, and they're not getting screwed by their tenants necessarily. They're just getting screwed by the system because it's not set up for people who aren't following the rules. Now speak to that.
So in this case, this is where I recommend that, especially this is a first-time violation sort of thing, where the landlord issue not a notice to vacate. This is the I'm terminating your lease. I have the right to terminate your lease because you have violated a provision in the lease that essentially puts you in default. And because of that, I can demand immediate possession. You got 3 days to pack your stuff and leave. That's probably going too far, even though you are legally entitled to that right. I would instead issue a notice of default in which you say, look, I see that you have an unauthorized pet. I'm going to give you a couple options. You can either remove that pet and no harm, no foul, or you can pay the additional deposit. Whatever harm is incurred with that, you're secured, I'm secured, we're fine. If it exceeds what is reasonable for you, then you may not give the option they can keep the pet. But if it's still within reason and they have paid an adequate security deposit for that additional pet, then all sins can be forgiven, and it's a business decision with a business solution that could work out for you and that tenant. And so long as everything else remains the same or every other provision is adhered to, I don't see why that isn't a perfectly reasonable resolution.
And so I can just imagine how effective a letter like that would be, basically saying, I can throw you out on a dime. In this case, we're going to do this. And basically you're just, we were talking about benevolence before. This is basically showing mercy. You got the justice you can bring, but you measure it out and you document it.
Right.
And you basically put them on notice that if you do this, I can bring the hammer down, and I will. And what I do for anyone listening to this, if you feel like you're playing the heavy, I just blame it on my attorney. I said, I've gotten in legal trouble before, and my attorney will not allow me to do anything but this. I don't say my attorney, Ernie Garcia, but
right. He's a bad guy.
Yeah, but it's just these things that really make the world flow, and it puts them on notice. And
well, I think it's also a calculated business decision. So it's not exactly a matter of extending mercy. That
right.
might be the way. And we look at these things in terms of grace and mercy and benevolence, but really it's a calculated business decision, right? You have to consider the cost of an eviction.
Good point. Yeah,
and then you consider the cost of allowing this alternative to eviction, and when you measure that, it more than likely makes sense to say, hey, you know what? I've already got a tenant who is otherwise really great at paying rent on time, who's got this one violation, which I can live with as long as they make up for it in this specific way. We're good. The tenant gets to stay. I've established possibly better rapport with them based on the way I've handled the situation, as opposed to just kind of turning a blind eye to a violation. Because if you turn a blind eye to this, you'll turn it again over and over and over, and ultimately you're no longer enforcing important provisions in your lease, and you weaken your position. This other way actually strengthens your position, and again, could establish what might be years of tenancy with somebody you know and trust, and who you enjoy having on your property.
Well, I just, this question was called tenant screening, but later on, it was the lease.
Yep.
And how I just see these things, how once you have a breach in that enforcement and one, it's like in negotiations. You never want to ask, if you're dealing with a seller of a property and you know that they've just lied to you about one thing or another. You don't really want to ask them that. You don't want to ask them a question that you know they will be tempted to lie. So you have to carefully craft what you're going to ask them, because if they lie to you that second time, then the whole relationship is going to go just start going a lie after lie after lie. And you don't know really where that first lie came from. And it could have been a mistake or whatever. Once you do something and you stray off the reservation, get off of that, that really makes it a whole lot easier, a whole lot more difficult to come back on.
Yeah, that's exactly right. And we talked about it in the main broadcast of, you give a little leeway here, you give an inch there. Ultimately, you're going to put yourself in a bad bargaining position.
Yeah.
And so you want to enforce some things, but you're willing to let 20 other things slide. That doesn't put you in a strong position. If the tenant understands that you're going to enforce 100% of the lease, they are likelier to comply with 100% of the lease.
Yeah, and they get the idea when you just give them violation after violation that you're letting slip by for one reason or another, that you're still not giving up any of your rights.
Right, and I would say, if you want to institute a 3 strikes and you're out policy, once you get to a third notice of default, it's probably time to move on. You don't want to just stack paper and say, well, I'm calling you on violation number 204, and just keep stacking that paper. Once you get to 3, then they've established a pattern that I think indicates to you it's probably time to move on.
Yeah. And you want to mention your tenant scorecard again? You can get on your website?
Absolutely. So if you go to attorneyeg.com, there is a button called Landlord Resources. You'll get access to my tenant scorecard as well as a huge database of frequently asked questions with information and videos there that I've posted. Free content for any landlord who has questions. You might see your question on there. Click on that. You'll get access to some video content, and you'll be able to see precisely what I have to say on that subject.
Good deal.
I had a landlord who said, I've got a tenant, a terrible tenant. They always pay late. So that's the first light bulb that goes up. If they're always paying late, then the way I hear is you're always allowing your tenant to pay late. Okay, so that sounds less like a tenant problem and it sounds more like a lease enforcement problem. And so if you're not enforcing your lease, you need to start doing that. But in this particular case, we had a landlord who was enforcing their lease. They were just enforcing a bad part of it because along with accepting late payments, they were accepting their stated late fees, which for 1 month actually exceeded the amount of rent that they were charging. Now, you may think, well, if that's the agreement, then they're bound to pay it. So let's say, for example, rent is $1,500 a month. The late fee provision says, as of day 4, if you haven't paid rent, I'm going to charge you $150 and then $50 a day thereafter for every day that the rent remains unpaid. Well, you can see that in a short amount of time, especially if the rent goes unpaid for 30 days. So 30 times 50 is $1,500. And then you got the initial $150 fee. That late fee already exceeds the value of the rent itself. And you may think, well, the parties agreed to these terms and we're bound by the terms that we signed, but that's not what the Texas Property Code says.
Right.
So the Texas Property Code limits landlords, and this is a law that was recently put in the book, so it hasn't been around forever, but it limits landlords in single-family homes or up to a 4-unit, multi-spot residence to 12%. You are capped at 12% of the rent. And many landlords just don't know this, and they blow right past this and have a documented history of accepting these late fees. Well, what they actually have is prepayment to future rent.
Yeah.
That they don't know about that could later come and bite them in the rear when they are trying to enforce non-payment of a certain month. The fact that you are enforcing a bad provision in your lease could actually subject you to future punishment. Again, we get into trouble when we add special provisions. That's what we talked about in the main broadcast. But we also get into trouble when we have provisions that exceed what the Texas Property Code allows us to collect in terms of late fees.
Now, I got a question on that.
Yeah.
So if something like that happens, then later on, you might be found in violation of some onerous, where you cause damage to the tenant.
Right.
And then they can have something else to sue you on. And talk about the roles being reversed.
Right. And so where this tends to pop up is when some other part of the lease is being enforced or some other cause of action is being investigated and that tenant has counsel and maybe this is years after the tenant has left. I'm going to paint you a scenario. Let's say that you and the tenant argued over some repair that you had to do, and when it came down to them having vacated and requesting their security deposit, you said, nope, you're not getting any of that security deposit. I had to replace the entire carpet for the home because of X, Y, and Z. And so this tenant, after months and even years of requesting that deposit, finally gets fed up and hires counsel. And that attorney comes back and says, look, I believe you wrongfully withheld that security deposit and that you owe them the security deposit back.
With interest and
Well, not just with interest, but with attorney fees and court costs if we file a lawsuit.
Yeah.
And then on top of that, they review the record and they say, by the way, you improperly collected fee after fee after fee in violation of the Texas Debt Collection Act, which could triple damages.
Right.
Right? And it doesn't matter that you didn't know you couldn't collect those fees. What matters is that you did. And the Texas Property Code and Texas courts are going to hold you to a standard of knowing what the code says. You can't benefit from the landlord-tenant law without following it. If you don't know whether or not you're in compliance, you're walking around with a blindfold and you're likely to trip over your own feet.
Wow.
And again, if you have questions, you need to find somebody who knows.
Right. Or go to your local RIA and join Alamo RIA or the Greater Houston RIA and rub elbows with people that are going through this or have gone through it.
Right.
Every story you've had, you know, when we get our RIA group going and that rental focus group really gets going, there's going to be lots of stories in there. And so there's also the rent perfect, you know, basically having some kind of a set standard way that you do things. And now, one thing we did not talk about the TREC contract.
Right.
Yeah. So can you speak to that? Because we didn't cover that today.
Now, when you say TREC, and this is a common designation, I think what you mean is the Texas Realtors contract, or what was formerly the Texas Association of Realtors.
Yeah, because there is no TREC residential lease contract. Yes, I'm talking about the state contract.
Right, and so there is a statewide organization, Texas Realtors, or again, it was formerly Texas Association of Realtors.
Right. Yeah. Now, TREC is a government agency.
Correct.
Yes, and so the TREC contract is something that the agency has agreed on. So there is no government contract for landlords.
Right. Not for leases.
So this is an association. This is an association of realtors, property manager types that have gotten together. Okay, so this is a professional association which has close ties with the with TREC and everyone.
Right, and so they've got a big lobbying group, and they've got their own attorneys, and they've got this lease that many landlords who work with realtors who are part of the association have access to use, and many landlords have used this lease or version of it throughout the course of their landlording experience. It's a great lease, and again, many of the provisions in there are tried and true. Courts like this lease because courts are familiar with this lease, and so it helps to go in and you know precisely what's in it. Some of the things that we talked about, access to property, that's in there. The application of funds clause, that's in there. One that's near and dear to my heart, attorney fees provision, that's in there. A lot of good stuff is in that TAR or the Texas Realtors lease. If you have access to it, I recommend it because it's a very solid lease.
Now, who can use that lease? I know that this is not the TREC lease, so this doesn't come from the government that's owned by everyone. This comes from the TAR.
Right. If you are a member of the Association of Realtors, the Texas Association of Realtors, you have the ability to use that lease. Whether you are managing property for someone using that lease, or you yourself are a licensed realtor and a member of this organization for your own rental property, you can definitely use that lease. There is a prohibition to non-members, and they are not allowed to use it. However, if your lease is similar in kind but a different document, then you can rest assured that similar provisions, as long as they do not deviate from the essence of the provisions in the TAR lease are just as good in a Texas court. However, this is where landlords get themselves in trouble when they modify terms and unknowingly invalidate provisions in their own lease. So I would consult an expert, consult someone with years of experience who you trust, who has the TAR lease or their own lease, and get answers to questions before you get yourself in trouble.
Yeah, and so I'm a civil engineer in my former life, and so we dealt with big contracts all the time, and we dealt with standard contracts. And even among the engineers, there was a feeling like, oh, if we're not an attorney, we cannot go in and modify any language. And we always took the tack that no, that's not necessarily exactly. It's a good practice. But usually we were dealing with small matters on where we would change. For us it would be changing the National Society of Professional Engineers Services contract. It's similar to the TAR here. Not a government agency, but a standard deal, which the courts were familiar with because of this everything being standard. What should if there's a small clause to change, where does it really concern you when you see clauses that have been changed by, obviously, there's some real, zingers out there that you've run across, but there's some others that are just afraid to do it because, they're not an attorney, but they don't want to go pay the $200 or $300 that it takes to get an attorney to review something and give them some advice. Can you speak to that and give someone a feeling as to what they might be able to take as a change? And it could be something as simple as modifying a term of a pet deposit or something like that.
Right.
Oh, I'm not an attorney. I can't touch that contract. So can you speak to that?
The kinds of things that make me queasy, that word you used earlier, that standard lease. So I just want a standard lease. The truth is there is no such thing as a standard lease. There are popular leases that are out there, but there's nothing that has been standardized necessarily and adopted by the state of Texas. Right. And so, we can't assume that anybody's lease is standard in any way. In fact, when I hear that, I hear malpractice, right? Because I don't want to call anything standard. And then, the rules change and now you no longer have that standard, right? What we want is for landlords to have a lease that they understand and that complies with the law as it is presently enforced. Right. And as we know, you could have a lease that was quote unquote standard 10 years ago that is no longer that. Right. You believe it is, but you don't know where it deviates from current law. Is my lease still in compliance with current law? You mentioned something about, well, maybe a landlord doesn't want to spend the money and maybe consult with an attorney. And so here's maybe a biased opinion in that respect, but you may find that it's money well spent. And one thing that I, again, from a business perspective, I tell a landlord, look, you can go buy your own paintbrush, your own bucket of paint, and go paint your house. Or you can pay Joe Painter to go do it for you. He's done it 1,000 times. You've done it 2 or 3 times. It's going to take him less time, and he's going to cut those edges real nice. Whereas you're not, right? Your house isn't going to look quite as good. You're going to save $1 or $2, but in the long run, you're going to lose money because the value of your house is going to be different. The value of the job and the investment that you put into this work is going to be reflected in the kind of work that was put into it. And so the same thing could be said of having a professional look over your lease, right? You may spend money to have that done, but ultimately you may save hundreds, if not thousands of dollars by getting rid of something that doesn't belong in your lease or adding something that should be there that's not there now. And so, and it doesn't have to be an attorney, right? Maybe it means investing your time in a group like the Greater Houston RIA and spending the time capital to educate yourself, to, like you said, rub shoulders with people who are doing the same thing and who have banged their own head a few times, from whom you can learn.
Right. And I guess also learn which courts around give more problems than others when it comes to.
Yeah, and the courts
it may
are
affect your
changing.
business decision on a rental property,
Absolutely.
whether you're in Montgomery County or Harris County, north or south.
Right.
this precinct or that.
One of these things, and it kind of relates to the previous topic of a bad lease, is the idea of your ability to enforce the lease you have in place now. And sometimes that means eviction. We see sometimes from landlords that they purchase a property that has a tenant there, and they also purchase their lease. And they take it subject to the terms of that lease, and they never update it.
Yeah.
The lease ended years ago, and it's now lapsed into a month-to-month. You're not running this like a business. You're not protecting yourself beyond the 30 days that a month-to-month lease allows. And so one business decision that you should make is updating your lease every single time. Don't just allow it to stand on its original terms. And again, we talked about how that lease that was signed was old when it was signed and needs to be updated. If you don't know if that's the case, you need to educate yourself. But then also, once you're in a month-to-month, you only have protection for 30 days. That tenant could at any time give you a 30-day notice saying, I'm out. And now you're without a tenant. Whereas if you lock somebody in for 6 months or 12 months, you have a certain set of guarantee. Of course, nothing's perfectly guaranteed, but you have a better outlook for how you can plan the use of that money, the use of that leasehold, and essentially what kind of advertising you need for that place, as opposed to constantly being on edge. Will they stay? Will they go? You can give yourself a degree of security by establishing a term with, an otherwise very good tenant.
Excuse me. What does a law allow or dictate when you go at the end of the lease, you go month to month, and it's been a while since I've read a lease. Does a lease cover that? Does state law cover that?
It's a little bit of both. So your lease might give rules for how that lease is going to be terminated. It might also say, for example, that there is no automatic renewal. However, that's where state law kicks in. If, for example, your lease says no automatic renewal, this lease absolutely ends May 31st, 2021. But the tenant stayed and you accepted rent on June 1st. And so by virtue of offer and acceptance, you have extended the same terms on a month-to-month basis.
Okay.
So by default, unless you enforce that absolute cutoff, it automatically renews. Now, many, especially the TAR lease, many leases have an automatic renewal. And so it's understood unless someone gives notice, whether it's 30 days or 60 days in compliance with the lease, it's understood that the lease will simply continue for infinity, right? And so you really don't have to do anything. It's when someone says, I'd like to terminate, that the rules in the lease and the rules of state law, which by default are 30 days. Mm-hmm. If it's not stated in the lease, then Texas law requires at least 30 days notice to terminate a month-to-month lease. And as long as the parties follow either the Texas Property Code or the written terms of their lease, they can end it. But if you've got a 6-month or a 12-month or an 18-month or 24-month term, there's nothing in the code, there's nothing really in the lease, short of some really extenuating circumstances where someone can say, you know what, I just want to bow out early. Mm-hmm. You just can't do that. And so by having that term, you essentially lock in the rent obligation for the length of the term. If you utilize your lease like a tool, and you don't see it as a formality, just some document that you got to sign, because that's what landlords and tenants do, but you see it as a tool for your business, and you use it that way, you will make money. If you don't give it the respect and don't honor its terms, you will likely lose money. Mm-hmm. Simple as that.